I am Ornsuri Junshaya. I am the Deep Tech Incubation Manager for the Chulalongkorn University Technology Center. And today we have a very special program. As part of the MedVentures Incubation program, we have a special masterclass today. And the topic we'll be exploring is artificial intelligence and machine learning IP strategy. So in intellectual property for software and AI, this is a very new area for us in Thailand. And Thailand is actually one of the countries that unfortunately has one of the lowest outputs in terms of software IP. All right, so without further ado, let's jump into our session. So I would like to introduce our special talker today, Kirk Sigmon. So Kirk has worked in the US and in Asia for Fortune 500 companies and also startups. And he actually began his legal career in Tokyo, in Japan, and works with US, Japanese, Korean, Chinese, and European intellectual property matters. And his cases also involve a broad range of technologies, including gaming, computer networking, cellular communications, virtual reality, machine learning and artificial intelligence, military weapons systems, blockchain technologies, aerospace, petroleum, optoelectronics, data storage, magnetics, agronomy, and toys. So everything, almost everything under the sun. And so Kirk is also one of Managing IP's rising stars, and he has successfully represented both plaintiffs and defendants in multi-million-dollar patent infringement trials in federal court. He is also an active member of the business community, both in Washington, D.C. and abroad. And Kirk has counseled startups and spoken at startup and M&A conferences around the world. He's also a frequent contributor to the blog Patent Arcade, where he writes on video game intellectual property laws. And before joining Banner and Witcoff, which is the law firm he's currently at, he has worked with clients in response to the Department of Justice, Consumer Financial Protection Bureau, and also the Securities and Exchange Commission investigations. And Kirk is also devotes also a significant amount of his time to charity and pro bono matters. So once again, I'd like to welcome Kirk Sigmon, who is a partner of Banner and Witcoff, to come give us this special talk on intellectual property strategy with a focus on artificial intelligence and machine learning patents for medtech. Thank you so much, Kirk, for joining our talk.
Oh, thank you very much. Let me go ahead and present my screen here to begin our presentation. Okay, now hopefully everyone should be able to see that. Just to confirm, can you see the slide deck?
Perfect.
Cool. All right, I'll begin then. So thank you for that very kind introduction. Like she said, my name is Kirk Sigmon. I'm a partner in Banner Witcoff. My day-to-day nowadays, that is to say, what I do very regularly every week, especially this year, has been focused on artificial intelligence and machine learning. So this is a topic that is very familiar to me. It's something that I'm dealing with on a daily basis. And hopefully I can keep this entertaining while also giving you as much information as I can about what is happening internationally, including in Europe, in the US, in Japan and Korea, and how that might have implications for your concepts as you might consider whether or not you should patent them, when you should, and so forth. But before I begin, I want to sort of point out the obvious disclaimer, which is that this is not legal advice necessarily. This is a speech regarding what I've seen in the intellectual property space. This is a standard form disclaimer I'm required to tell you. So I cannot give you specific advice about your legal needs. I will try as best as possible to help you, kind of guide you in the right direction. But when it comes down to your particular needs, you really should talk to a local attorney, oftentimes because they're much more familiar with Thai patents than I am. So, but before we get into this, let's begin with the market overview. And some of you have seen parts of these slides before. So I did a similar presentation about a year ago where I talked a little bit about, hey, we're seeing growth in artificial intelligence and machine learning as it pertains to intellectual property. Now it's going crazy. It is exploding with popularity. Every single day I am working on some form of a patent that has some form of an artificial intelligence or machine learning aspect. The popularity of AI and ML in patents is a gold rush. Everyone wants to be involved. Part of that is because now many major companies have realized the value of having these patents. It is a good way to get around some certain limitations regarding subject matter eligibility, particularly in Europe and in the United States. But it also is something that simply they recognize as a valuable form of technology. This applies in virtually every industry. It applies in the med tech space, it applies in the pharmaceutical space, it applies in the computer networking space. There's not a single area where I've not seen it present. In fact, typically with many patents, especially those that we file in Western countries, we're filing them with what we consider to be standard figures. So, what a computer is, what a network diagram is. Now, virtually every patent we're filing has a third standard diagram, which is what is machine learning. Virtually every single patent we're filing now talks somewhere about machine learning. So this chart, many of you might have seen this before. We're seeing, generally speaking, a significant growth in artificial intelligence and machine learning. There has been discussions about this concept for years because, let's be real, there's been development on this for years. But the patent world is finally catching up. And part of the reason why, as many of you likely know, is that you can get your hands on machine learning models and tools to use machine learning much more easily than you could 10 or 20 years ago. And as a result, many companies and many patent applicants are testing these in different embodiments. So for example, an engineer in a computer networking concept would never necessarily have used machine learning before, but now since they can easily get their hands on machine learning tools, they might be more likely to go test that. So that's why we're seeing this sort of explosive growth in both scientific publications and patent families. The industry world is catching up, and this chart is old. I think if we were to extend it out to 2021, that is around now, we would see that the patent families were likely in the 100,000 or more. Many of these patents have not yet been published, so we have to speculate as to how strong that interest is right now. Indeed, in the United States, you don't have to publish your patent for quite some time. So there is a good possibility that this chart is misrepresentative. In fact, I believe the patents are likely greater. Now, who in the world is filing these patents? Again, this is an old chart because realistically speaking, it used to be most of what I'll call the people you would expect to be filing AI and ML patents. IBM used to be the sort of dominant party in that because they were doing a significant amount of research in that area. You see here Microsoft, some Chinese companies, Sony in Japan, of course, Google. This, again, like I said, is quite old because there are other companies who are discovering the value of filing AI and ML patents. So virtually every industry is going to have at least one or two players, that is to say, one or two different companies who are exploring these concepts. So one thing I want you to keep in mind is we're talking about medtech, of course. Don't forget that we don't necessarily know who is pursuing AI ML patents yet, because they don't have to publish them yet, because we don't necessarily know what their internal processes are. It is very likely that major pharmaceutical and medtech companies are already involved in the space and have already been involved for years. We just haven't seen the proof yet. So what are we saying? This is, generally speaking, an overview of my perspective on what's happening. And this is my perspective because oftentimes companies will come to me and many of my colleagues to discuss getting AI and ML patents. So what will happen is when I'm working, I will receive a request from a company, hey, we'd like to discuss whether you can help us get artificial intelligence and machine learning patents. And that's how they phrase it. They ask me to help them get AI ML patents. They don't necessarily want patents on something else. They want to cover AI ML specifically. Oftentimes they're telling their inventors or their engineers, go figure out what we can do with AI and ML. It's a very unique scenario because typically companies make their discoveries in a natural way. They say, I'd very much like to invent, a new drug. They spend a lot of money researching that drug and eventually they possibly invent something. Here, the companies are saying, no, we want to specifically target patents and inventions related to AI ML, even if that invention is relatively minor. So as you see here on the slide, it says there's a rush for AI ML patents. I am getting calls about this constantly. I am working on a daily basis to help companies get artificial intelligence and machine learning patents. There's a huge demand. And it's great. I mean, obviously, it's a fun area to work in, but we should be concerned about that because if you're interested in getting an AI ML patent, you should be aware that everybody else is too. So there's a lot of competition. Another dynamic that we've seen is that the patent offices are smarter. The US Patent Office used to not totally, completely understand machine learning. That was both a good thing and a bad thing. On one hand, it meant that we could get patents relatively easily because they understood it to be a very complicated topic. So they were more likely to give an applicant a patent. They would say, okay, well, that seems very complicated. Here's your patent. On the other hand, now that when they didn't know it, we would have a hard time explaining the concepts, so the nuance would be lost. Now, most patent offices, especially in Europe, the United States, and to a lesser degree, my experiences are in Korea and Japan, they know what artificial intelligence and machine learning are. They're very talented at the topic. So what they're doing now is expecting more, like a higher level of disclosure. They're expecting better inventions, for lack of a better term. So again, you see their higher expectations. They want to see more than AI ML concepts. I'm going to touch on that a little bit in a moment, but just keep in the back of your head, just remember that the patent offices are expecting more than just a trained machine learning model. That doesn't fly anymore in most patent offices. And then finally, we're seeing more research in general. What we're seeing is because so many companies are focusing on AI ML right now, and because so many of them are publishing papers and patents and discussions, it is much harder for anyone to get a patent in the space. And that's good for you. Don't necessarily think that's a bad thing. Because if someone has published a scientific paper and the requisite amount of time has elapsed, as to say they have not filed a patent, but they published a paper, that oftentimes protects you if you want to use those concepts, because if they don't have a patent, they can't sue you over it. And because they've publicly published it, no one can get a patent on it. So it's, for lack of a better term, free territory to take. Nonetheless, keep in mind that it also prevents you from getting a patent. If something is published out there by someone else, then you cannot go get a patent on that. So before I jump into filing strategies, I want to stop here briefly to see if anyone had any questions. I can't speak too much to what my clients are doing, so please don't ask me about that. But what I'd like to do is make sure that I touch on any questions you have specifically about what I've discussed so far in terms of the industry.
มีคำถามไหมคะ อย่าลืมนะคะถ้ามีคำถามสามารถเขียนเข้าไปในแชทได้เลยนะคะหรือว่า raise hand แล้วก็ถามคำถามได้เลยนะคะถ้ายังไม่มีคำถามเดี๋ยวไป next session นะคะ I don't think there are any questions at this point, Kirk.
Okay. So I'm going to jump forward over to what I said, filing strategies. So now that we have discussed the overall market trend, what I would like to do is talk a little bit about ways in which, when you decide to file a patent, you have to best optimize your chances of getting that patent. So we're not talking about whether to file a patent. If you're concerned about that, my recommendation would be to speak with a local attorney, because your circumstances will be different than everyone else's. What you have to consider will be different, and critically, the approach you take with various countries will be different. I'll talk about that in a little bit. But for now, what I would like to do is speak a little bit about filing strategies. And once you've decided to make that patent a reality, once you decide to apply for that patent, what do you do? Let me show you an example of something that is a very bad idea. This is something that was happening, or this is an example of patents that were being filed 10 years ago or so. You can see here it was published around 2017. So this was likely filed 2015, 2016. What this is an example of is a very bad approach to patenting machine learning. And the reason why is because what it is doing is simply pursuing machine learning in the abstract. Now, I'm exaggerating a little bit. What it's really trying to do is patent a trained machine learning model, which is a very bad idea. You see here on the left, that's the claims. The claim is what defines the scope of your invention. So what's on the left there, that one sentence in English, is the definition of what you could sue someone with. So if you had to go pursue a company who was, you would say, practicing your patent, stealing your idea, then you would use that claim to say, well, they're doing exactly this. And you see there on that left-hand side, that claim says, receiving sensor data, that's step one, classifying the sensor data, and there's some detail there, but essentially classifying it into one of two classes using a predictive model, trained on data labeled by at least an agent computation component, the computation component including a platform to query an agent. So that's a very complicated language. All it's really saying is we're classifying that data into one of two groups, and then we're providing the classification. So this claim says nothing more in very fancy terms and with some complexity than getting data, classifying data using a machine learning model, and then providing the classification. That's not enough nowadays. In fact, the company that filed this application abandoned it because they were not going to get a patent from this. They applied, they asked the local government to provide them a patent, and they did not receive it because it's just a trained machine learning model, and there's no way to win that. Now, another thing I'll point out to you is there's not a very clear target market for these claims. What do I mean by that? I don't know who you would sue with this. Oftentimes, a good machine learning patent is tied directly or indirectly to your industry. So in the case of medtech and pharmaceutical, anything else you're working on, you don't want to hide what you're doing. In this case, I don't know, and I don't think any of us would really know what this company is trying to pursue, what industry they work in, because it's outside of the context of that. It's just not a great target. You don't know who this would be used against. Now let's turn to another example. This is what I call a risky example. This is a patent claim that is risky to file nowadays because, speaking very candidly, it will cost you a lot of money to prosecute. That is to say, you will have to argue with the government for years, and candidly speaking, it will take a long time to acquire. So what it says is here, he says a computer implemented method. Let's skip over that. What it basically says is it's for evaluating an individual for a behavioral disorder, developmental delay, or neurological impairment. This is already better because we're already saying, hey, look, here's what we're doing. We're trying to figure out whether they have or evaluate their behavioral disorder, developmental delay, or neurological impairment. So there's some market there, but let's look at the actual steps involved in this method claim. It says step A, displaying a plurality of questions. So it's asking you questions as to, for example, a behavioral disorder. Okay. Receiving input comprising a response to at least one of the said plurality questions. In other words, we're asking someone questions, we're receiving answers. Thus far, this is not very machine learning focused, is it? And then step C is where they put all of the machine learning. They say, generating an output indicating whether said individual has behavioral disorder, developmental delay, or neurological impairment based on said input, wherein said output is determined with statistical accuracy of at least 90%. Uh-oh. This is not much, right? It's barely machine learning. The patent discusses machine learning, and it implies that there's machine learning, but it doesn't have machine learning. It's short. It doesn't go as far as it should. And the critical fact here is, even though the applicant, the inventor, intends this to involve machine learning, it says virtually nothing about machine learning in the claims. So in reality, will this patent get granted? Who knows? What will likely happen is that they will have to spend tens of thousands of US dollars arguing with various governments around the world as to whether or not it should be allowed. Unfortunately, that money would go to someone like me, where I would spend a lot of my time arguing with these offices and changing these claims into something that recites machine learning. So one issue here is it's risky because it's expensive. You're not going to get these claims, or you're likely to not get these claims at least. What you will get is a rather long battle with various patent offices. Now, that will especially be in countries like, my understanding is the Thai Patent Office has a very low bar, very low tolerance at least, for software patents. So this is not enough, generally speaking. Now let's give a better example. This is US patent number 10478112. This is a decent example. Now, this is not perfect, but it's better. So on the left-hand side, and I apologize that the font is rather small, it says, look, what it does, it's again relating to behavioral disorders, developmental delays, or neurological impairments. But let's look what it says. It says it's displaying plurality questions, like the last one we looked at. It's receiving an input, like the last one. So we just asked a bunch of questions, we received data. Now what do we do with it? It says here, generating an output based on said input, using a software module comprising a classifier trained with data from a plurality of individuals having said behavioral disorder to said developmental delay or said neurological impairment. Okay, that's not my favorite wording. I'll get into what my favorite wording is in a bit, but it's better, right? We already hear, okay, there's machine learning here. Machine learning is actively being used, and it's being trained in a very particular manner. We've already contextualized, we're providing the detail that we need to explain what our machine learning model is doing. Now it says here, and there's also two what we call wherein clauses. One of them is what's familiar. It says wherein said output has an accuracy of at least 9%. The other one's kind of interesting. It says wherein said output comprises an indication of whether said behavioral disorder, said developmental delay, or said neurological impairment is present in said individual. So we're specifying some interesting things. We're saying, here's how that machine learning model should be trained. Here's what it is outputting. And here's how accurate that machine learning model must be. Now, I don't like the accuracy part. I think that's a little weird. I don't necessarily think it's required. But critically note that we've described a machine learning model in terms of how it is trained and in what context is being used and what it is telling us. Now, I'm still not the biggest fan of these claims. They're not the greatest nowadays. In fact, if I were to prosecute these nowadays, I think I would have difficulty with the US Patent Office, maybe, but especially the Europeans. They tend to not tolerate this quite a bit. So let's talk a little bit then about what we've learned from these examples so far. The biggest thing I want to emphasize, if you take away one thing from this presentation, is that you cannot get a patent on what I call the black box. The black box is a term I refer to refer to a trained machine learning model without more. And it says here, now I'll just be blunt, with very few exceptions, trained machine learning models are not patentable in Europe, in the United States, in Japan, Korea. I would assume so in Thailand as well. Generally speaking, you cannot just patent a trained machine learning model. So on the right-hand side of the slide, you see what I call an example claim. This is something that I've written. It doesn't reflect a real patent. This is an example of something that you should not waste your time pursuing. It says, training the machine learning model to detect a disease, providing input data, and receiving output data. Now, it's similar to the one we just looked at. So perhaps that last one wasn't strong, like I indicated. But this is not enough nowadays. Most patent offices will not give you this. The reason why is very simple. Most patent offices have in their laws a definition that says that something that is obvious cannot be patented. And most patent offices construe obviousness to include use of a machine learning model to solve a problem that exists already, or to indicate just pure data. So what they will do is say it is obvious for one to use machine learning to solve problems, to analyze data. And two, it is obvious for a physician or someone else to try to diagnose or detect a disease. You put the two together and it would be obvious to what we say is a person of ordinary skill in the art that a physician or clinician would use a machine learning model to aid them in detecting or diagnosing a disease. I know that's a little unfair, but that is how they view it. They say there's a world of references and scientific publications about machine learning. There's a wealth and world of publications and thought about diagnosing and detecting diseases. The two of them could be combined together fairly easily, especially now where, like I said at the very top of this presentation, there are many companies who are already pursuing these types of inventions. So they don't have to make huge leaps of logic. They just say, look, other people are doing it. Major pharmaceutical companies have already published numerous papers and patents relating to this exact concept. So again, if you take one thing away from this presentation, it is this: do not patent the black box. So let me give you an example of one approach that I like to use with machine learning. If you are going to patent a machine learning algorithm, this is the most common way that we are seeing allowances across the world for machine learning patents. It's what I call the clever approach, which is not very smart, but let me explain. It is use of an artificial intelligence or machine learning model in the context of a larger problem. And by which I mean in the context of introductory processes in context, as well as processes after the fact. So you see here in this little orange box here is you see first process, second process, which creates input that goes into an AI/ML model, which creates output, which is then processed further by a third process and fourth process. In other words, the AI/ML model is not standing by itself. So I'm going to hop back a slide here. Remember, this is just input and output. It's just saying put data in, receive data out. This is different. We have many other things that are happening that are improved by the artificial intelligence and machine learning. So again, this is more than a trained artificial intelligence or machine learning model. It is significantly more. So on the right-hand side, I've created an example claim. I apologize, it's kind of silly, but I'm doing it to give you an example, a very simple example of what this might look like. So let's say you invented a way to use machine learning to modify the temperature of a room based upon patient vitals. Okay, let's say, and I know this is extreme, but just play with me for a second. The first step here you see is it says train the machine learning model. That's not enough, but it specifies something interesting. Using training data comprising a history of room temperature values correlated with EKG measurements. So we're not just saying the machine learning model happens to be trained with anything. We're saying specifically that a machine learning model has been trained to associate room temperature values and patient EKG measurements. If I wanted to go even further, I could say that it is trained to output a recommendation of, say, a temperature change. So what we're doing is we're showing that we have provided two sets of data. One set of data which relates to, say, temperature, another which relates to EKG measurements. And what we're doing with that machine learning model is trying to train it, in effect, to draw correlations. So from the very beginning, we're explaining in this claim, in this legal definition of our patent, what we're going after, that correlation between those two sets of data. We're then going to receive from an EKG machine patient data for a first patient. Note that this data does not come from nowhere. We're specifying this data is still in the computerized format. We're receiving from a specific machine in a specific context, a very specific form of data. It's not patient vitals, it's EKG machine data specifically. Then we're going to provide that patient data to the trained machine learning model. Now, of course, we've just gone through the first process, which is training, of course, but now we're just going to go ahead and use that machine learning model. There's no harm in using machine learning model. Once we've received output data from the machine learning model, then we're going to take an additional step. We're going to transmit, based on the output data, a signal to an air conditioning unit configured to modify a temperature of the room associated with the first patient. What does this mean? It means that we're doing something with that output. We're not just taking the output in and feeling good about ourselves. We are taking the output and we're going to use it. Oftentimes it helps to do something automated, not give it to a clinician, not give it to a doctor. What we want to do is take the output data from the machine learning model and do something cool with it that is still computerized and useful. Now, one thing I'll flag for you here is you'll notice that this involves, at least arguably, 3 different devices. We've recited an EKG machine, we recited a computer device that is performing this method, and we've also recited an air conditioning unit. That's good. We're providing a system, a world in which this machine learning model operates. So when you're considering whether to patent something and what your patent would look like, keep in mind that you want to paint a picture of the world in which it operates, not just one computer by itself. If you can explain how different computers are working together to perform this process, it's wonderful. So for example, if you're doing an imaging invention involving processing images from, say, a camera or some form of a tool, then make sure that you consider whether or not you want in your claim to include that tool or camera, because it explains where your data is coming from. Now, this, I apologize, this is kind of complicated, but this is my currently preferred way to approach the first style of claim 1. So I've broken down here into 4 steps. I think it's important that you remember that you want to explain that you train the model, you receive the new data, you use that model to process that data, and then you do something useful with the output from that model. So I want to point out a few things here. First, with respect to training the model, you want to explain how you train the model and why you train the model. So when I say how, remember you have to explain, or you should explain, what the data contains. Don't just say that the model is magically configured to do what you want it to do. You've trained the model, explain how you did it. So for example, here on the right-hand side, I have a different example claim involving identifying pictures of dogs. So what it says here is using training data comprising a plurality of pictures of dogs in different environments. So we're saying, look, we're training a machine learning model with very particular data, which includes photos of dogs in different environments. That way it can identify the dog. And then we also ideally want to specify why we're doing that. So on the right-hand side of the claim, you see it says to identify a dog in a photograph. In other words, we're giving you a lot of data to teach you to find a dog in photos. Then eventually we're going to receive new data. Here you see on the right-hand side, I'm saying from a CCD sensor of a camera. So again, just like the previous example, I'm tying this to a specific environment, and I'm tying it to specific other computing devices. We're then going to use the model. So in other words, the same thing we've seen before in many of these examples, we're providing that data to the trained machine learning model and receiving output. Then we're going to do something useful with it. So in this example, I had to kind of come up with an example that's not great, but it's okay. I say transmitting to an alarm system, and based on comparing the output data to a threshold associated with the perimeter of a property, a notification that a dog has entered the property. It's a dumb example, I apologize, but it is an example nonetheless. We're not just sending the output to a person. We're not just storing the output. We're doing something with the output. This is extremely important. So again, something to keep in mind is if you are pursuing these patents, you can sometimes summarize your training process. You can sometimes summarize the receipt of the data, but please keep in mind that you want to explain what you're doing with the machine learning output. If it's just going to a human being in virtually every patent office in the world, you will have a difficult time getting a patent. I'm going to briefly touch on what I will call my approach 2. This is something that I suspect few of you are working on, but I'll point it out anyway. There are instances in which you can patent improvements to machine learning itself. So if you are dynamically reconfiguring nodes, if you're creating a very particularized form of machine learning, you can, in some instances, pursue a patent to that. Now, this is not very medtech focused. I suspect many of you want to do this, but I will keep something in mind. If you are having to reconfigure existing machine learning models, that is to say, before training, if you are having to modify the way in which they operate to do what you need them to do, there's a possibility you can patent that. So for example, if you have to reconfigure nodes before you begin training the model, it is possible that itself is patentable. This is a very different sort of patent. It is extremely difficult to get nonetheless, and it requires a lot of proof as to why you had to do what you did. But I would keep it in mind. If during the process of your work, you find that you're having to take standardized form models and reconfigure them, perhaps that is something to consider patenting as well. Now, I do not want to discourage you, but I will be very blunt. Even these strong artificial intelligence and machine learning patents, even the ones that I bless and I think are great and they're strong and they explain input and output in context, even if you're doing something cool with the output, it's going to take you a very long time to get those patents. On the right-hand side is something from the United States Patent and Trademark Office showing that typically speaking, for all patents, for the most part, it takes about 2 years to get a patent. Realistically speaking, it's going to take much longer for an AI/ML patent than that. So in Europe, it can be just as long, 2 years, 3 years maybe. In Canada, oftentimes it's quite as long. Japan and Korea, about the same. I would imagine the Thai patent office is about the same. These patent offices are extremely busy, and it is their job to tell you no. It is extremely normal for the first application you file, the first response you get will be no. Now, you can argue against that, and it does not mean that you cannot get a patent. But you should expect that the first response you get from the patent office will probably be some version of no. And that's okay, because that's where my job comes in, is to argue with the patent office, to change the claims, to correct problems, and to get you that patent. But keep in mind is once you begin to take your invention and put it into an application, it's still going to take some time. Now, if you're in the United States or if you're in many countries, legally you're allowed to say you are patent pending and you are allowed to sell the application. We'll get into that in a little bit. So it does not mean that you cannot go market yourself. It does not mean that you can't sell your company to an investor or get angel funding. All of those are possible. But just expect that it will be a difficult process until you get that patent grant. So I've touched on a little bit of these. I will not bore you with this discussion, but I want to emphasize that when you do decide to file a patent for your AI/ML invention, you want to do so carefully. Now, needless to say, these are things that an attorney you work with will explain to you, and they will help you with all of these. So don't feel like you have to do these, but these are just things to keep in mind. So when you go in that first meeting with an attorney who can help you file a patent, you know what you want to focus on. But the first thing I want you to focus on is having a story. All of you are creating inventions that have real world use, right? As far as I understand it, you're trying to improve the world, right? So to do that, they have implications. Why is it that you're doing what you're doing? What problem are you solving? And as you see here, what are you doing better than existing inventions? So oftentimes the better is faster, cheaper, easier, something like that. So keep in mind, what is it that your invention does that no one else in the world could do before? The second point is I want you to be realistic. Many inventors are very excited about their patents, and that's great, except you have to be realistic. There are other people who invented things before you. And what that means is what you have invented will oftentimes be very focused. None of you, I imagine, invented artificial intelligence or machine learning. What you might invent is an implementation of artificial intelligence and machine learning. So the question is, what did you invent? What implementation did you invent? What specific little change did you make to the world? Focus on that. Remember that if you file a patent directed to machine learning, you probably won't get it. Now, another thing that I have an idea is that be aggressive. At the very beginning of this presentation, I told you, and I'll tell you again, this is a very popular field. Many, many people are interested in machine learning and artificial intelligence patents. So you must move as quickly as possible. Talk to an attorney as soon as you can. Once you do, and many, many countries have this, use what are called fast track procedures. So in Europe, for example, they have a fast track procedure. I believe that is still free. In other countries, there are costs associated with them, but they are often quite small compared to other costs. Use these procedures to get your patent considered quickly, because remember, everyone else is also trying to get a patent. So the faster you move, the better. That said, do not use this as an excuse to rush. You want to think carefully about what you're doing and your invention. There is no harm in thinking things through more carefully if possible. And finally, I want you to think long term. I will get into this in a little bit, so just keep this in the back of your mind. Your first patent will not be typically your best patent. You can have subsequent patents from the same one. In other words, sometimes you have to think the long game. When you're talking to angel investors, oftentimes they will not be thinking about how valuable your current patent is, but they will be considering whether or not they can do what's called a continuation or divisional off that patent, and whether or not they can configure that to be more useful for them. So I'll get into this a little bit later, but keep in mind that your first application, the first set of claims you file, do not need to be perfect. They just need to be realistic. So one thing I want to flag for you, and this is especially important for everyone watching this, is I want you to consider filing internationally. The United States continues to be one of the dominant players in this market, but that does not mean that you should not file anywhere else. In fact, you need to keep in mind that your competitors, the people who might see value in your patent, either angel investors, potential competitors, research institutions, they're all over the world. So keep in mind that you should consider at least what we call the big five: United States, Japan, Korea, Europe, and to some degree nowadays, China, depending on how you view it, Australia, etc. You want to consider at least where the important people are. Thankfully, this is not a very hard process. There are existing strategies for filing internationally. You do not have to write a new patent application for every single country. If you speak with your attorneys, it's called the PCT process, the Patent Cooperation Treaty. So once you do realize where you want to file, so for example, if you want to file in, let's say, Europe and China, you can do so using the same process. So thankfully, that shouldn't be too difficult. You can use the same set of claims. They will have to be translated, which is oftentimes a little bit of a cost, but ultimately it's worth it. So before I move into my next section, I want to give an opportunity for any questions. It looks like there have been a few. Do we have any questions before I continue?
Yes, I'd like to call up. Okay. We have one question in the chat room right now. So this question is from Kunra Wit. Does transfer the output to a physician so that they may more accurately make a diagnosis constitute do something useful? I think this was in response to one of your earlier slides.
Yes, so I'm going to pull that slide up. Hold on.
And Kunrawit, if you wanted to come up onto the stage for the Q&A session as well.
Oh, yeah, thank you. Yes, that's just my question about what you can do with the data that's been processed.
Sure. So this is a very common problem. Many of my clients have this exact problem because the answer in short is it is useful. It will be difficult to get with a patent office. The reason why is because many patent offices law state that something that can be done by a human or with pen and paper is not eligible for a patent. So the language in the United States, at least, is that essentially that anything that can be done in the human mind or with pen and paper is not patent eligible. So a claim limitation like transfer the output to a physician, it gives patent examiners, as I say, the government, and a sort of excuse to say that that portion of the claim is not actually an invention. So, like I said, though, my clients have the exact same issue where they want to cover that exact implementation where they're providing notification. One way that many of them have figured this out is to say, well, even if the output is ultimately going to a physician, it has to go to them in a certain manner. So for example, if we're going to transfer it to a physician, are we providing it as part of an updated health record? Are we providing it as a notification in there by virtue of an email, like of some kind? Are we adding it to a database? So they're looking into ways in which it's provided to the physician such that they have a more technical explanation of that process. My usual rule of thumb is to never have a human in the claim. So for example, if I were to write that, I would say something to the effect of transfer the output or cause the output to be transmitted to a smartphone associated with and I wouldn't even say associated with a physician, cause it to be transferred to a smartphone and displayed in a manner which indicates a modification to the patient's, like a process or their medication or something like that. So if you're thinking that way, A, you're thinking the right way. B, I would deeply think about perhaps ways in which you can characterize it with a more technical aspect, even if it is still going to be reviewed by a physician. Does that make sense?
Yes, thank you very much.
All right, thank you. มีคำถามเพิ่มเติมไหมคะช่วงเซสชันนี้ถ้ามีคำถามสามารถเขียนเข้ามาในแชทได้เลยนะคะ Okay, I think we're ready for the next part, Kirk.
Awesome. Okay, so this is going to be more of a fun part because it's not as scary and it's a little more fun. We're going to be talking about how to make money with your patents. Now, I know many of you probably this would be a wonderful idea that will come sometime down the road, but I want to explain to you how these work a little bit more because there is oftentimes a misconception among startups that patents, either you have to sue somebody or not, and the first patent is what will get you attention from angel investors. These are correct up to a certain point, but they are also slightly incorrect. So I'm going to expound upon a little bit about how, once you get a patent application or a patent, how that might play out when it comes to making money or preventing competitors from doing what you do. So let me give you an example of what a patent family looks like. Like I said, your first patent does not mean it's the only patent. In virtually every country in the world, you are allowed to spin off with some regulations and rules what we call continuation patents or divisional patents. In other words, I first file patent 1, and then once that is granted by the office, I am allowed within a certain period of time to file a continuation, which claims priority. It has the same priority date, which means if I filed in 2012, file patent 1 in 2013, then I filed patent 1 in 2012, I can file patent 2 in 2013, and it still claims priority back to 2012. So I can continue on in the same family forever, or at least until they all expire. What is important to understand is this can continue into massive patent families. This is a relatively small family. Once you file your disclosure, if you have multiple ideas in mind, if you have multiple implementations in mind, you can have multiple patents from the same document you filed at a certain time. For example, I work with some inventors who filed I would say about 50 pages worth of a patent application back in 2012. And they now have, I think, conservatively 20 different patents from that one filing. We've worked with them. We still work with them to this day on that exact same filing. Now, that also means that first filing needs to be really good because you'll be working with it for years and years and years. But keep in mind, you can have this sort of family. So the first time you file your idea, it is very important to keep all of your concepts in that application to detail yourself as much as possible, because it is very possible that 10 years from now, you will still be getting patents on the same concepts, or at least variations of the same concepts. Here's how it plays out though. Typically, in most patent offices, we start with what we call a narrow set of claims. We start with the very focused, very detailed set of claims. So remember, the claims are the things we were discussing before that define the legal parameters of what your patent is. So the first time we come to the patent office and say, I would very much like a patent, please give me a patent. What we do is we come in with a very long claim that says, this is exactly what I'm doing. This is precisely what I'm doing right now, with all the detail I can possibly provide up to a certain point. I am trying to be as honest as possible, and I am trying to be as focused as possible. It can be as silly as saying that, instead of saying I'm training a machine learning model to detect disease, it's saying I'm using a machine learning model on this type of computer using this type of software to detect this specific disease. Then from the continuations, we begin to broaden. In other words, we begin to explain the concept more broadly. We remove portions that are not required for allowability. So for example, perhaps we don't say what software we use for machine learning. Perhaps we do not say how we are training the model, or actually we should how we're training the model. We give the definition of training data a bit more broadly. We don't necessarily say the training data has to comprise certain elements of data. We describe what we do after with the output from the machine learning model more generally. We say, well, we're going to use it in transmitting notification. What we do is we're trying to broaden out to encompass different concepts and different implementations of the same fundamental idea. So let me give an example outside the machine learning context. Let's say I wanted to patent a new car. The first application grant, the narrowest, would be a red car with 4 wheels, with a plastic interior, with 5 seats inside, with a 6-cylinder motor, yada, yada, yada. The next patent, the first continuation, I might try to say, well, it's a car with 4 wheels, with an interior, it doesn't have to be plastic, with seats, maybe 5, maybe 4, maybe 3, and it will have an engine. It could be 6-cylinder, it could be 4-cylinder. So what I'm doing is slowly but surely encompassing a bigger sphere of different things that can practice my invention. That second continuation might be a car with 4 wheels, no other requirements. Now that might be harder to get, it would be very difficult to get, but nonetheless, the example remains. I'm trying to expand my world out of it. Now here's the important thing. The patents that are most valuable for suing someone and most valuable to angel investors are those that come later, the broader ones, because it is easier to sue somebody over a patent involving a car with 4 wheels than it would be to sue someone with a red car with 4 wheels, a plastic interior, 5 seats, and a 6-cylinder engine. That's a lot of requirements to prove. That requires a lot of proof in court. They would much rather prove a car with 4 wheels. So from an angel investor's perspective, from an investment perspective, from a lawsuit perspective, what they want is simplicity. They want breadth. To the extent you can get it, there is such a thing as being too broad. Oftentimes that includes being so broad that perhaps during a lawsuit, they can argue that your patent should not have been granted because it is too broad, because it has been invented before. There are plenty of cars with 4 wheels that have already been invented, so it would be easy to prove that your patent should not have been granted. So keep in mind, you don't want to go too much in the breadth direction. But nonetheless, just keep in mind, your first patent is often not the one that would be asserted by a company in litigation. So you perhaps want to keep in mind that when you're speaking with investors, they're not thinking about this patent now, they're thinking about subsequent patents. This is the interesting dynamic though. When you are speaking with angel investors, you will probably be in the process where that arrow is. You will be after filing, before you receive your first patent. You will have a patent application filed with a government, ideally, but not much else. This is a great thing because it means that the angel investors, if they like your idea enough, can give you money or they can use their own attorneys to help make that patent stronger. So oftentimes, startups have to go fairly cheap with their first patent application. They have to keep their money simple. They have to keep their money where their mouth is and be cheap. So what they will do is they will hire a cheap patent attorney, they will get something on file, and they will not have much money for later processes. So for example, they won't have the money to argue with the government over whether or not they should be entitled to a patent. That said, angel investors and other investors have that sort of money. So what you can do is say, look, I have a patent application with the government, and we are still fighting with the government over whether or not I should be given that patent. If you give me money, I can then go pay an attorney to make that fight. And we can make sure that fight is in a direction where your investment will be realized. That patent will be valuable to you. So you can market a pending patent application. You can take that to someone and say, look, if you give me money, we can make sure that the patent is valuable against competitors, which means that the patent itself becomes extremely valuable. So I've already said this before, and I'll say this again. Your most valuable patents are oftentimes the later ones. But investors very well may want to involve themselves early on in the process. So one thing to keep in mind here is if you do file a patent application, there is extreme value in keeping at least one application pending. That is to say, do not rush to get a patent application. Granted, do not rush to have a patent in hand. What is oftentimes more valuable is to have an application pending, because that way someone can come in, involve their money, involve their attorneys, and turn that into something much more valuable. So another way I like to phrase this with some folks in the United States is have someone else pay for the really expensive part of patent prosecution. Have their money come in and fix that problem for you. Now, one thing to keep in mind when you are filing a patent is you want to target competitors. I know many of you probably do not want to go sue someone on your own. It is a time-consuming process. It is not fun. It is mean. It makes you look bad sometimes. It is a lot. But the patent is only as valuable as it can be used to defend you or to attack potential competitors. In other words, it's only as valuable as it can be used to stop someone from doing what your patent says in the claims. So when you're thinking about where to file the patent, consider where those competitors are or might be. So in the AI and ML context, especially in medtech, think where the medtech companies are. Think, okay, there are medtech companies in Europe. There are medtech companies in the United States. There are certainly medtech companies in Thailand. There are certainly ones in Japan and Korea. There are ones in Australia. Figure out which ones you think are most likely to practice your invention, to do the thing that you invented, and then make sure you have patent coverage there. Now, another thing to keep in mind is it doesn't just have to be the company. It can be where their customers are or where their business partners are. So for example, in the medtech and pharmaceutical context, this could include hospitals. So think, okay, where are the hospitals? If I had to sue a hospital, which you might not want to do, but sometimes you have to, where are they located? Where are the big hospitals that I could sue? You know, Johns Hopkins, for example, is in Baltimore, Maryland. So perhaps you would want to have a United States patent, because if you wanted to go against Johns Hopkins, you would need a United States patent. Now, I'm going to try to explain this kind of briefly because I know that this gets a little bit convoluted, but patent value is what I refer to as the value of the patent that you have filed. So it can be something that has been granted, that is to say a patent that you have, an official patent that has a number to it, or it can be an application that has not yet been granted by a patent office in any country. There's a few things that drive what makes a patent valuable. So in some cases, it's how much it costs you to make it or to develop it. So how much time you spent, how much money you spent filing the application itself, and then the opportunity costs that were involved in the time and the money you spent getting that patent. For artificial intelligence and machine learning patents, that can be difficult to prove. Many of you, if you were in a university, it's kind of hard to prove how much it costs you to do R&D because the university R&D costs are kind of sticky sometimes. Another area which is a lot more easy to work with artificial intelligence and machine learning patents are potential profits. So how much could you use if you sold your invention? So let's say you invented a new form of imaging for diagnostics. If you did that, then perhaps you would embody that invention. You would use that invention in a new tool, perhaps a little scanner or something, or like a computer software. The question is, how much can you sell that software for? That is a way to derive how valuable your patents are, to say, how much money am I making on this software tool or on anything else? Finally, there's this concept of royalties. That is to say, how much competitors would pay you to use your invention. Royalties can be calculated on a per product basis. So for example, if I allow my competitor to use my patent, perhaps they're paying me 10% of their profits on every sale. Perhaps they're paying me a flat fee of $1 million a year or something like that. These are hard to evaluate with artificial intelligence and machine learning invention. I'll explain why in a little bit, but suffice to say, it can be very difficult to prove AI ML patents in the first place, prove that someone else is stealing your idea. So it can also be hard to prove how much of their use is, royalty amenable in the first place. Let me give an example of this. Google Translate would be extremely difficult to value, because think about it. Google Translate likely involves some artificial intelligence and machine learning somewhere along the line, but it's free. And a lot of tools like this are free. It's facilitated by a lot of research by Google, but it's something that they don't really make money off of. And it involves a lot of different processes. So there are many different inventions that are likely embodied in Google Translate, maybe for different languages, maybe for different steps of natural language processing, maybe for different steps of the input-output process. So there's a lot of different aspects to Google Translate that are all involved for a free product. And let's not forget, this has a very distant relation to Google's profitable business. Google makes money off of advertisements and various business aspects. But Google Translate being free, it's not clear how much they would have to pay you to use your invention if you invented something involving artificial intelligence and machine learning for language. So it'd be hard to say how much they should owe you if they used your patent. And finally, even if they did use your patent, even if you could prove it, they could probably find a non-artificial intelligence and machine learning workaround. So all this is just to say that generally speaking, it can be very difficult to find a royalty that you can make from certain artificial intelligence and machine learning patents. What that means, hopping back to this previous slide, is that you want to focus more on the cost it took you to develop, which I said can also be difficult, and then the potential profits for selling it. So in your context, in many of the contexts in medtech, thankfully, the potential profit margins, the potential profit calculations can be a bit more straightforward, thankfully. But nonetheless, I will keep in mind that if you want to evaluate royalties, it's going to be fairly difficult. And that's just the nature of how artificial intelligence and machine learning are played out. Much like the Google Translate example, it will be difficult to show that anyone is actually doing what you're doing, your invention. And then even if you can prove that, it will be very difficult for you to avoid them creating what's called a workaround and just not using your invention anymore. So let's say you've heard all this and you've got a headache now and you're thinking, oh man, I can't get a patent. My idea is too generic. Maybe it's just a trained machine learning model. Oh man, what do I do? Well, there are two things you can rely on in most countries, to still protect your ideas. If patents don't work, there's two ways you can approach this. One of them is copyright. So copyright attaches to code in virtually every country in the world now. So your code, much like a painting, is an artistic expression. It is something you have created. So your code is copyright eligible. Copyright lasts a long time. So if you ever find yourself in a position where your ideas are not necessarily patent eligible, the code you have created to implement those ideas is nonetheless copyrightable. In other words, you can protect other people from stealing your code at least. Another example is what is called a trade secret. Now, trade secrets are different in virtually every country. There are many different rules for them, but the basic idea of a trade secret is if you keep something secret, such as the way in which you're training your machine learning models, the modifications you make to your code to make it work, etc. As long as you keep that secret, other people cannot steal it. So you may have heard these stories about corporate espionage where spies go into a competitor and try to figure out what they're doing. They're trying to steal trade secrets that are kept from the world They're the way in which you do business better than anyone else. So if you find yourself in the process of creating your artificial intelligence and machine learning invention, if you find yourself with a cool idea of how to do something, it might not be patentable. Maybe it's too generic. Maybe it's the specific way in which you train a machine learning model. But if you keep that a secret, just enough, if you keep the secret sauce to be secret, then what you can do is protect it from being used by other people. If they steal it, in many countries, you can sue them for stealing it. So in other words, you can protect that for yourself. Many companies rely on trade secrets for anything that they cannot patent that is nonetheless valuable from the perspective of, say, their business. So again, when you're working on your process, whether or not you want to consider a patent, keep two things in mind. One, the code you're creating is yours. So that alone you can protect. And two, if you find something that is not patent eligible, but nonetheless very valuable for your process, if you keep it a secret and consult with attorneys, because keeping the secret is a very specific set of rules, you can't just tell anybody, then you can keep that a secret from everyone and therefore protect it under the law. I will note, however, that I will be very careful because both copyrights and trade secrets are very often stolen. When you hear stories of Silicon Valley startups having stuff stolen from them, 9 times out of 10 it is stealing copyrighted or trade secret material. So when you hear these stories about departing inventors or departing employees running off with code from Facebook or something, they're stealing copyrighted code and oftentimes they're stealing trade secrets. So let me give an example of one way to protect yourself if patents don't work. It's called dummy code. So if you think someone is going to steal your code, which is very common in the academic context, so be extremely careful, I recommend putting in some indication that it is your code. Structure your code in a way that no one else does somewhere. So an example, and this is a bit of a history lesson, but about 100 years ago, the way people who made maps prevented their maps from being stolen in virtually every country in the world is they would put in fake streets. The streets were not real. The streets were fake. The reason they would do that is because if someone copied their map, they would copy the fake street not knowing it was a fake street. And then they could prove that this map was stolen or copied. In the same way, code can be done the same way. If you put in code that is non-functional or accessory or perhaps not as efficient as it should be on purpose, if you can find that code again in someone else's code base, that allows you to prove that someone copied and pasted your work. So think like the map makers from hundreds of years ago. You want to create in your code some way to indicate to yourself whether or not someone has stolen it. Now, I'll note that many of you are probably thinking, I'll throw in some comments. Comments are not enough. People know to delete those. There are even scripts you can use to delete the comments on your code. You've got to do more than that. Variable names are sometimes not enough because most people know now to change variable names. So that's not enough either. What you want to think of is, what are some interesting ways in which I can structure my code to make sure that if it was stolen, I could identify it as mine? Now, it depends on the code you're using. So I can't give you many ideas on that front. But again, don't use comments, don't use variable names, think of something more. I will note, however, that there are tools now that will help you identify when your code has been stolen. So it's not a process that you would have to perform yourself. Just make sure that your code is unique. Another example, this is just for fun. KFC is famous for having one of the biggest trade secrets in the world, which is the recipe for their chicken. Like I said, trade secrets are secrets you keep from the world that help your business. A chicken recipe, a spice recipe, is not patentable. So what do? It's a trade secret. They have the trade secret for the unique combination of spices they use in their chicken. So like them, you should consider, if I have a concept, a strategy, a formulation, a way to train an artificial intelligence or machine learning model that is not patentable for some reason, maybe you just keep it a secret. Be like KFC. Now, one thing I'll flag for you, by the way, is, like I said before regarding trade secrets, it must be kept a secret. Oftentimes it requires non-disclosure agreements and it requires strict control of the secret. So consult with local attorneys on this. You have to be extremely protective. If you have like GitHub repositories, that will destroy the secret. If you have open databases, if you show the secret off at a trade show, that will destroy it. So be extremely careful. So before I go into example applications for different examples of things that this could be used, do we have any questions? I think we might. I think I saw some chat pop up.
Yes, we have a question in the chat from Kun Tal Pang. Are these the cluster of evergreen patents?
Okay, so I think you're referring to probably this structure of different patent with continuations. The term evergreen patent, for those of you who aren't familiar, is this idea that many pharmaceuticals and medical device manufacturers try to keep their inventions alive by refiling patents with minor inventions. The idea being that, let's say a drug is about to expire, they'll refile their patent application with a different embodiment of that drug. That way they keep that invention alive for longer. In this case, it's actually not. This is a genuine, excuse me. Looks like I had a glare. One sec. There we go. Hold on 1 second. I will reshare my screen. There we go. Okay. So this is not an evergreen patent example. This is a way in which the patent offices want you to pursue continuation. So an evergreen patent, for example, the canonical example of an evergreen patent is I invented a new drug for, let's say I invented aspirin, because I'm being lazy. I invented aspirin, it lasts 20 years minus however much it took for me to get drug applications in and those sort of things. So in year 19, I'm like, oh man, I'm about to lose my patent and then other people can make my aspirin. What do I do? Then what they might do is file another patent application saying it's aspirin, but it's in gel capsule form. So that way I have the gel capsule form, even if I don't necessarily have the prior version. So I can threaten people who have used aspirin in a gel capsule form. That's kind of the way they do it. There's some other strategies there as well. They're not worth getting into. This is a little bit different. This is you telling the patent office, within those 20 years or however long the patent lasts, I want to continue filing different sets of claims directed to the same invention. So it is a friendlier way to go about it. It is a way in which you can continue to use the same priority date. So unlike the evergreen example, you would have the same time frame, the same 20 years within which to file these claims. And generally speaking, it is a more permissible use of the patent office. The evergreen concept, as I understand it, is beginning to die off. The patent office doesn't tolerate it as much anymore. But nonetheless, this is a friendly way of doing something very similar. Does that make sense?
Okay, any other questions from the audience? มีคำถามอะไรเพิ่มเติมไหมคะ Okay ค่ะ all right. I think that's it for this section, correct?
Cool. Now comes the even more fun part, where I'm going to talk about some specific applications of all this. I know that I've spoken a lot regarding theoretical concepts. It can be very overwhelming. Of course, we'll be sending out the slide deck, I believe, so that way you can look over this stuff on your own. And now I'm just going to be talking about applying all of this to medtech, pharmaceuticals, and everything else. So hopefully this will all bring it together where you understand why I have been talking so much about these different ideas. So let's talk generally first about artificial intelligence in medicine. So this is the general discussion. Like I said at the very beginning of this presentation, this is a very popular and crowded area. You should expect a lot of fight from the patent offices when you file an application. In other words, when you file your first patent application, you should expect that the government will push back hard because they know that this is a popular area. This is an area where everyone wants a patent. So they're going to make you prove that you are genuinely entitled to a patent. It's going to take you time. So remember, earlier on, I said it takes about 2 years to get a patent. Expect longer. Now, this might be a good thing for you, though, because, like I said, again, during the valuation section, sometimes you want to market the patent application, not a granted patent. You don't want a patent too fast initially because you want to be able to give investors the opportunity to influence the way in which that patent is prosecuted. So remember that it's not a bad thing. It's just, it might be a little discouraging because like I said, you will receive at least one no. You're not going to get an instantaneous patent. Eventually, you will receive what we call an office action that says, no, you're not entitled to that because this reason, this reason, and this reason. And you will have to have an attorney argue on your behalf. Eventually, you'll get there, but it's not a bad thing. You want that time. Now, again, something else to push back is you don't want to pursue black box patents. Patent offices are now very aware that people want to implement machine learning and artificial intelligence in the medicinal context. They are very aware that physicians would very much like to use machine learning for the purposes of diagnostics, for the purposes of evaluating various sets of data, etc. So that's generally speaking not yet enough. So that returns to the slide I showed you involving the input and the output. I want you to focus on what you're doing in context and what cool things you're doing with the output of machine learning. Now, again, with respect to valuation, you really want to identify who your potential competitors are early, because medicine can be in the context of hospitals or in the context of pharmaceutical companies or biotech companies. It's very important for you to identify where you might want to file your patents. Again, though, remember that I mentioned what's called the PCT process, the Patent Cooperation Treaty process. That is easy. That's probably the way you should go. My understanding is that many of you might be eligible for discounted rates with the Thai Patent Office. What you can oftentimes do is use the Thai Patent Office filing to create a PCT application. I would speak with attorneys about that. That might be the way to go with it. Let's talk about image recognition. My understanding is that some of you might be working on image recognition technologies. Now, again, trained machine learning models are not enough. So what that means, in other words, is you want to do more than the trained ML model. So one thing that I have seen, and I'm sure many of you have seen before on the internet, are machine learning models for self-driving cars and other forms of sort of traffic evaluation. It would not be enough for you to pursue an AI ML patent relating to identifying a car in the street. One, someone has probably done it before, and then two, even if someone hasn't done it before, the government might nonetheless argue that it is obvious. Instead, like we've been saying from the very top of this, focus on what happens before and after that, orange box I showed you earlier. Focus on where that data is coming from, what type of data you receive, where it's received from, what computing devices are involved in the receipt of that data. And then also focus on what you're doing with the output of the AI ML model. So for example, what am I doing in response to the output I'm receiving? What I like to do in this context, especially in the image recognition context, is automate a process. So for example, let's say I'm a bank and I'm using AI ML as part of a check scanning process, like the manual checks you write out, they scan them with a photograph. Maybe we're using machine learning to analyze parts of that check. What do we do with the machine learning output? Well, we could do a lot of things. We could automatically deposit money into someone's account. We could notify them that the check has not cleared or has cleared. We can do a lot of fun things. That's the kind of mentality you should have. Not just the model, but also what you can do with the output of that model. Now, this is also an area where I would think back to my discussion of copyrights and trade secrets. If you have code that helps improve the image recognition, so for example, pre-processing of the images before they are provided to the machine learning model, or perhaps some sort of trade secret as to how you're training the machine learning model to better identify things in images, maybe you keep those as a copyright or trade secret. With respect to valuation, I want you to keep in mind that there is a fairly big risk here that someone else will do a better machine learning model than you. So your invention really should be more than a trained model anyway, because if it's just a model, someone might be able to train something better than you can. Focus again on what's happening before and what's happening after. What is it that you are doing that has an impact on the market? What are you improving and why? The machine learning model itself should be but one step in a bigger process for the image recognition system. Now, this dovetails with my discussion of diagnostics. Now, this actually relates to the question I received before. It has to be done, something more that can be done by a human. So let's say we have an image recognition algorithm for diagnostics. We're taking CT scans and we're processing them with a machine learning algorithm. That seems really cool, except that most patent offices are likely to push back because, like I said, their perception is that machine learning models are known and the analysis of CT scans are known, such that the combination of the two would be obvious. Instead, focus on what it is about use of machine learning models that makes it different. On one hand, they can do so very quickly. So perhaps the trick here is to do so faster than a human can do and to provide some sort of automated step that is faster than a human could ever perform. That said, it probably should be more than that. So again, let's go back to the example I provided where we're processing CT scans with a machine learning model. Ask yourself, what do we do with that output? If we just provide it to a physician, it probably will not be sufficient for the purposes of getting a patent. So perhaps we want to analyze what it is about that analysis that we can do. So for example, let's say you're implementing it with some software that a technician might use. Are we modifying the output of the user interface to reflect the processing machine learning? Are we guiding a physician in a certain direction using a user interface? In other words, we're trying to figure out some computerized way to implement what we've gotten from output from a machine learning model. Now, one thing I'm going to warn you about is other companies are very aware of this problem. And what they do sometimes is create extremely lengthy claims that try to over-explain the diagnostic process. So they think to themselves, so like, let's say you're a major diagnostic company, for example. They know that a trained machine learning model is not enough. They also know that a human should not be necessarily involved in the patent claim. So what they think is, okay, how do I fix this problem? Well, maybe I over-explain myself. Perhaps what I do is I have a very long claim that explains different nodes that are involved in the machine learning model, that are explaining different ways in which we process the training data and so forth. Be careful. Those lengthy over-explanatory claims can be difficult to assert. That is to say, they can be difficult to use in a lawsuit. As a result, they will be less valuable than they otherwise would be. So there's a trade-off here. Either you go too broad and you explain your diagnostic process way too broadly, in which you find yourself arguing with a patent office for a very long time, or you go too narrow, in which you're explaining the process with too much specificity, in which you might get a patent very quickly, but the patent might not have any value. That's a very careful trade-off. So when you're thinking about these things, when you speak with your attorneys, keep in mind, you want to find the adequate balance between those two areas. You want to explain your concepts enough where the patent office will give you a patent, but not so much that the patent becomes valueless. Let's talk about pharmaceuticals. Now, this is an extremely complicated field, and I will not pretend to you that I am an expert in all pharmaceutical stuff because virtually no one is. Understand, however, that pharmaceutical concepts are much more complicated because pharmaceutical IP in itself is regulated much more strictly in many countries. By way of example, in the United States, there's an entire process, separate, of course, from the patent process to get FDA regulation approval and everything else. And then the patent system interplays with that to allow you to, for example, in some respects, keep your patent a little bit longer. Nonetheless, you need to keep in mind the same principles we've discussed before. Even though the regulatory environment might be more strict, even though the patents themselves might be more specific, you should keep in mind the AI/ML principles I have discussed thus far still apply. So even though the pharmaceutical implementations we might be discussing are much more complicated and thus might be more easily granted by patent offices depending on the system, the machine learning concept should still have more than just a trained machine learning model. In other words, let's say you invent a new drug for arthritis. You feel very good. Yes, you've invented a new cool drug for arthritis. That does not mean that you can go file a patent application that involves providing data about that drug to a machine learning model and receiving output, and that's it. It's just a bad idea. First of all, the patents for the arthritis drug should be separate. Once that's done, whatever you do involving pharmaceutical implementations of machine learning and artificial intelligence models should be very separate from that process and should be more than a trained machine learning model. The same principles apply. Don't get confused about it. Now, with valuation concepts, this is definitely something to discuss with a attorney, because very candidly, the nature of your targets will change based on the drug you're involved with and what you're going after. Oftentimes, the patents that I have seen involving AI and ML in the pharmaceutical space have involved evaluations of test data. Okay, so it's not necessarily just the drug, it's involving test data. In that context, not only is it a bad idea to pursue the model trained alone, because evaluations of test data using machine learning, that's out there. But it's also hard to figure out who you're going to sue. Oftentimes it will be other pharmaceutical companies. So when an investor comes to you and says, who can I use this patent against? It will necessarily be other pharmaceutical companies. So you have to need to think, who are those companies going to be? It is unlikely that these patents, these AI/ML patents, would thereby be used by hospitals unless that hospital is involved in the development of the drug. So this all sounds very complicated. The takeaway from this is speak to your attorney and think extremely carefully about this. Do not let the regulatory environment confuse you over the basic principles of how AI and ML should play in this field. And here we have medtech. So with respect to medtech, this is an extremely crowded area, and I apologize because it's just going to be a tough one. Medtech was a very popular area for many companies about 5-10 years ago, especially. And with respect to, for example, smartwatches, there were many companies that watched companies like Apple getting involved in their health kit system and became obsessed with the idea that they wanted to also get patents in this space. So you have two problems here. One is artificial intelligence and machine learning patents are already extremely popular and in demand. So many companies are trying to go after them. And then two, there are already years and years of experience with companies trying to go after medtech patents. So the two of those together mean that it's an extremely crowded space. You will have many people going for similar patents. In other words, you will have a very difficult time getting a patent directed to medtech and AI/ML. You should try if you have a new idea, but just expect to receive a lot of difficulty from patent offices because they've been receiving applications directed to medtech and directed to AI/ML for years. What you can do to help yourself is tell a persuasive story. Figure out what it is that distinguishes you from everyone else and what products you might use in that process. And remember that because products might change, so for example, it might not be a smartwatch, it might be a smart necklace or something, that you don't want to tie yourself too deeply to a specific implementation. Even though you're telling a persuasive story, that does not mean that you should tell the story as I'm using an Apple Watch version 5. You should tell the story as I'm using a smartwatch, I'm using a smart device, I'm using some form of a wearable, right? Don't get too specific in your desire to explain the story, especially given the pushback from the offices. Now, with respect to valuation, one thing to also keep in mind is because this is a very popular area and was a very popular area for some time, there is a low barrier to entry for startups. In other words, it's good for you because it's not hard to get involved in this process. It's also bad because you will have many different people who are competing with you for attention, especially when it comes to venture capital. I was in a pitch competition recently where I was on the panel, and a significant number of the pitches were in some way, shape, or form related to medtech because everyone wanted to get involved in the medtech space. So keep in mind that you are competing with a lot of people and the valuation might be more difficult. You may have a harder time convincing investors that your patent will help you. But if you receive a good, strong patent, that will make you stick out because it's something that other competitors will not have. Now, one thing to flag for you, by the way, is that because this is a crowded space and because many of these innovations are being developed kind of in view of the Silicon Valley, Web 2.0, 3.0 model, many people are trying to put these inventions out for free. So, for example, it is theoretically possible that a startup would invent something relating to AI and ML and medtech. So, for example, something that would execute on a smartwatch or a wearable and then provide it as an app for free. That is a real risk, and it means that your valuation will be shaky. I would speak with your attorneys, and I would also think carefully with your business side about what you can do to address that problem, whether you should come out as a free product with a paid version of it, what you can do to add value in a way that is not necessarily, it makes you competitive from a business perspective, but also allows you to make money and to file a patent and do the things you want to do. Finally here, I want to talk about Thai language processing, just because this is an area that is sort of frequently discussed in terms of language processing. When we talk about AI, ML, natural language processing in general comes into play. And it's another example that is, the canonical example of why you should not file a patent that is directed purely to a trained machine learning model. You will probably not be able to pursue a patent that says a computer that understands Thai. You will not probably be able to get a patent application granted if that patent application claims a machine learning model configured to receive Thai and output English or vice versa. Realistically speaking, these are things that the most patent offices would consider to be obvious. So consider the following. what changes to AI/ML would you make that would make the process better? So what is it about the Thai language or the interplay between Thai and English that would make the model different than, say, a conventional language processing algorithm or a conventional translation algorithm? What is it different? And then what makes those changes so effective? So perhaps there are elements of Thai, unlike other languages, that would require a configuration, a specific configuration of a machine learning model. Now, I'm hypothesizing here. There could be a variety of different differences. There could be a variety of different distinctions. But again, remember the very first slide I showed you regarding implementations of claims in the machine learning context. You do not want to patent the black box. Always focus on what you're providing before it and after it. What type of data are we receiving, and what kind of things are we doing with the output? So, and again, with valuation, this is extremely difficult. Google Translate's free. We discussed that earlier. And again, there you might be able to get something with respect to copyrighted code and trade secrets. So before I end, I want to just pull back the slide we showed you very earlier. And this is the one that I want to keep in mind every single time. That little orange box is the thing that if you take one thing away from this presentation, I want you to focus on that. Of course, also don't patent the black box, right? That's another thing to keep in mind. But the logical extension of it, have processes before and processes after. This is the key. When you're thinking of your invention with AI/ML, I want you to think, what am I doing in the environment? What input am I receiving? Where is that input coming from? And what am I doing with the output machine learning model? It has to be more than just sending it to a human being or just storing it on a hard drive. So with that being said, I believe I'm actually done. I'm going to go ahead and go to the very end of this slide deck. And I think we have a final opportunity for any questions that we might have. I think we have some time left, so I'm happy to answer any questions you might have.
Thank you so much, Kirk, for that super useful presentation, and also for sharing with us your experience and also real-world patent examples. I especially liked your little trick about adding some dummy code in to catch people that might be copying your source code. So that's super useful. So to kickstart the Q&A session, I will ask you a question that a lot of our medical or just startup entrepreneurs are interested in as well. And so that would be, do you have any tips in how to select a good patent attorney to work with, especially when it comes to software patents or artificial intelligence patents?
Sure. So there's a few things to keep in mind. The way most patent attorneys are trained is most of us began in industry first. So most of us are required by law, local law, be it in Thailand, be it in the United States, be it in Europe, wherever, to have an engineering background of some kind. More critically, that does not mean that they have to have engineering background in the field in which they're working. So the first thing to keep in mind is you want to find someone with a background that relates to what you're working on. Now, because AI and ML are new, that does not necessarily mean you're going to find someone who worked in AI ML before. Candidly, most of us haven't, because it's so new and because the form in which it currently exists is so new. But many of us now have experience prosecuting these patents. So the first thing you should check on is, do they have experience prosecuting, that's to say pursuing, patent applications involving machine learning? Ask for examples. After a while, most patent applications are published. There are some exceptions, but generally speaking, most are published. So ask for examples, see if they have done it. Most people will be able to provide you good examples of the patents they pursued. Now, there are many patent agents who will tell you, I know a lot about ML because they've thrown the words machine learning somewhere into a patent. That's not enough. You want to see a patent that genuinely involves an implementation of artificial intelligence or machine learning. So the fact that you can use a word search to find the words machine learning or artificial intelligence in a patent is not enough. Ask them to provide you an example of at least one application that's been published, if they can, that shows some version of artificial intelligence or machine learning being used in the claims. And look for the things I just showed you, the idea of an input and output. Lazy patent attorneys will do one of two things. Either one, they will do that black box concept I showed you. They're going to pursue a claim that says receiving input, providing it to a machine learning algorithm, providing output. If they do that, they might not be very knowledgeable of machine learning, or they might be being lazy although in some instances their client might have told them to do that. Another thing that they might do, which is also a bad sign, is if they are pursuing the machine learning patent with very long claims. So if you see a patent claims, the little one sentences things I showed you before, and they're an entire page long or longer, they might be required to do that for various reasons, but I would be very judgmental. I would try to evaluate why they felt they had to do that and what sort of context they did. So in other words, the basic answer is look for someone who has experience in some form of computer science, software, electrical engineering, something like that, but also who has actual experience prosecuting artificial intelligence machine learning patent applications. And take a look at it, see what you see and see what you like. Now, I want to place a disclaimer here. Even though you should look at those applications, keep in mind that sometimes we don't have perfect control over the subject matter. So don't judge a patent attorney if the applications aren't very clever, if they are wordy, if they are kind of silly, because that just happens. Unfortunately, the reality is, for lack of a better term, you have to patent what you have available to you. But nonetheless, I would take a look at what they've done and make a critical evaluation of whether or not you think that they fairly represented the concept of artificial intelligence machine learning. That's a very good way to sort of filter down from patent agents who think they can do it to those who actually can't do it.
Thank you so much, Kirk. All right, so let's open up the Q&A session to the audience. มีท่านไหนมีคำถามบ้างไหมคะตรงช่วงนี้เป็นช่วงเวลาที่สามารถถาม Kirk ได้เลยนะคะก็จะมาให้คำปรึกษาเกี่ยวกับทางด้านการจดสิทธิบัตรนะคะด้าน AI แล้วก็ด้านซอฟต์แวร์นะคะโอเคค่ะทางทีม MedVentures มีคำถามบ้างไหมคะตอนนี้ก็ของทางทีม MedVentures ก็เห็นมีเป็นทีมที่ทำเกี่ยวกับพวก AI เข้ามาเยอะเลยนะคะที่ตอนนั้นเราได้ทำเกี่ยวกับด้าน prior art search หรือว่าทางด้านfreedom to operate search ไปนะคะทางทีมไม่ทราบว่าทางทีมได้เจอ patent ที่เกี่ยวกับทางด้าน AI หรือว่ามีคำถามที่อยากที่จะถามคุณ Kirk ไหมคะถามได้เลยนะคะสวัสดีค่ะอาจารย์ขวัญ
พูดภาษาให้พูดภาษาอังกฤษหรือพูดภาษาไทยคะต้องภาษาอังกฤษใช่ไหม
ค่ะถ้าภาษาอังกฤษได้
ก็ดีโอเค Hi
Hey
okay thank you for your great talk for us we have planned to develop a virtual simulation platform online to teaching interprofession education ทีนี้and we have planned to develop AI for help teacher to assessment the learner by develop a dashboard and be able to tracking and see the opportunity to improve of learner. My question is for patent. This is in our plan. It's not finished yet. We will have minimal viable product soon, upcoming months, and we working on working on patent. My question is, if it's not happening yet, but we have what we want to do exactly in our mind, can we do a patent?
So the short answer is yes. I'll explain a little bit about the details. So generally speaking, most countries do not require that you have a finished product before you file a patent application. What they oftentimes require is that your idea is sufficiently definite so that you can explain it and you can explain how it works and the details behind it. So by way of example, if I invented a new airplane, I don't have to go build the new airplane before I patent it. That said, you want as much detail as possible. So it sounds like if you have a minimum viable product within the next month, that you do have that detail in mind. So by way of example, if you have a minimum viable product involving the artificial intelligence, it sounds like you could probably explain what you're doing in terms of training the artificial intelligence and how you're using it in the context of evaluation. So that would be a good start. And I think that would be plenty enough to speak with a patent attorney about what you should do with it. So the basic answer is yes, absolutely. You should go speak with an attorney sooner rather than later, oftentimes because even if you only have sketches, diagrams, things like that, that's sufficient. In fact, most of the applications I prepare and file are from ideas that have not yet been finished, right? I receive whiteboard drawings rather than anything else.
Oh, wow. Thank you so much.
Yeah, no problem.
Thank you.
Thank you, Dr. Kwansiri. Okay, for the next question, we have Professor Sipat. เชิญค่ะอาจารย์
Hello.
Asking questions. If you could please open your video as well. เดี๋ยวรบกวนอาจารย์เปิดกล้องด้วยนะคะถ้าสะดวก ขอบคุณ
Hello.
ค่ะ
Hi, Kirk.
Hey there.
Thanks for the talks. So I'm working on the medical software in the category of software as a medical device.
Okay.
Okay. So my question is, when we file patent for this, what kind of proof and by how much do we need to provide? For example, like if I'm talking about accuracy of my model or the whole system, like can I just say that like this is the test internally for the company, or do I have to like get someone else to kind of validate my system and put in a patent to validate that, or do I need a clinical trial or something like that? How much do we need to go, like, to what extent?
So you definitely don't need someone else to take a look at stuff. So that's the good news, is you don't need someone else to evaluate your work.
Okay.
That said, it raises a good point, which is if you have internal models, if you have internal notes, you should be providing them to your patent attorney. Because we are specialists in the area, you don't have to prepare something special for us. You can send code, you can send notes, like I said, whiteboard photos. So,
and from your experience, would that be enough to get a patent grant for that purpose of supporting your claim?
For the purpose of supporting, yes. So what a patent agent can do is take whatever you provide and draft it in the formal way in which explains what you're doing, and that should be sufficient. Now, because I haven't seen everything, there may be some areas they have questions, but what you're describing to me should be sufficient for at least drafting a patent application. Now, needless to say, whether or not the government grants you a patent is unfortunately a different story because you never know what they'll argue. But for the purposes of preparing the document to file, it sounds like you have enough to at least speak with an attorney.
And what's a common practice then, or best practice on the market? What do they do? Because I saw some patent from, I forgot from somewhere, that they do kind of like very detailed research and show all the graphs and stuff like that. That kind of patent, do we need to do that, or like is it necessary to do that?
It helps, and I'll explain why. So though it is not necessary for most countries for you to show that level of detail, although I will note that in the pharmaceutical context it can be, it helps because in many countries you have to prove that what you're doing has a sort of benefit, and it's not a legal requirement as to show a benefit, but the legal requirement oftentimes requires that you show a distinct sort of improvement over what is out there already, so that your software product, for example, performs better than existing solutions. So along those lines, that's why many different companies will provide test results and things like that. If you have it, that's always good, and it never hurts. But what I would do is, in your case, I would prepare everything you can to speak with the attorney about it, and then discuss with them where you might need to make those arguments. It's possible you don't need the research, though in some limited instances, it is possible you would. So if you prepare it up and give it to them, they might be able to tell you, for example, if it would require proof of sort of efficacy, for example, then you could do that research. But in the broad context, for most countries, they do not require proof that your invention is super effective. They just require proof that you have your invention and that you are adequately describing what it does and how it works.
Okay, so start off with internal proof would be sort of enough.
Right. And
okay,
I will note that, especially in the biotech and pharmaceutical context, the different inquiry usually is, safety and efficacy for the purposes of regulatory approval. That's separate. So unfortunately, you might need it there. But for the purposes of a patent, between me and you, there are many patents that exist that don't work that well. They're just kind of bad. So it's not unusual just to file something and say, hey, I promise you it works, and that's it.
Yeah, so
but I would recommend attorneys.
SDAs are two different things, right? That's what you say. Okay.
Exactly.
Okay. All right. Okay. Thanks a lot, Kirk.
Yeah, no problem.
Thank you. All right. Any other questions from the audience มีท่านไหนมีคำถามอีกไหมคะสามารถที่จะพิมพ์เข้ามาในแชทได้เลยนะคะหรือว่า raise hand ได้เลยค่ะ Okay, we have a few more minutes for a few more questions. All right. We have Professor Yingyot. He has a question. เชิญอาจารย์เลยค่ะ
Hi, Kirk.
Hi there.
I think your answer is very encouraging for the innovator to file patent. Now, I have question from the viewpoint of the tech transfer officer. If you talk to the innovator and they come to you with the patent, how do you know that patent is high or low value? I mean, how do you value the patent? Is that in the context of this meeting at all? I'm not sure.
I think it is a little bit. I'll walk you through how I look at things. Let's see here. Here we go. So big picture is it depends on the way in which the patent might be used. The way to think about it is if I am representing a company that might purchase a patent. So for example, if I'm or if I'm representing a potential investor, the most valuable thing from my perspective is how valuable that patent is in terms of how it can be used against potential competitors, even though I might not want to sue anyone. So keep in mind that a patent it is a tool for suing other people, even though you might never use it as such. So there's a few ways that might play out. One of them is if I'm an investor and I want to invest in a company, the reason I want them to have a patent is to provide them an opportunity to prevent people from unfairly copying them. So even though you might never have to sue anyone, it proves to me that their underlying concept cannot be copied by other people. And that in and of itself is valuable as a protective measure. It can also be protective because let's say the field is competitive. So let's say this is a startup in pharmaceutical where there are big pharmaceutical companies. If they have a patent, that patent or family of patents may protect them from being sued for infringing other patents. So we call that the shield use of a patent. What that means is if they have a patent that would also protect them from being destroyed should they accidentally copy someone else's idea. So I look at that dimension of it. So there's two ways to think about it. One way is, okay, if I invest in this company, if I purchase this patent, how much could I get from someone from suing them for it? Another question is, well, how much value is there in the underlying company being protected from being copied? And third, the question would be, how much value is in there in protecting this company? How valuable is this patent in protecting a particular company from being sued relating to other patents? So in terms of the actual equations, what happens is once an investor gets interest, oftentimes they will hire what's called a patent valuation firm or just essentially an accounting firm or something like that to evaluate what they perceive to be the value of the patent. Now, that gets extremely complicated. In the United States, there are factors that they take into account. I believe there are more than 10 different factors that take into account. The equations are quite complicated. The equations can change based upon the industry. So for example, a pharmaceutical industry might talk a little differently than the industry. But all of those concepts boil down to how much can I sue somebody with it? How valuable is it to protect me from competition in general? And then how valuable is it as a shield to protect me from being sued from other patents? Does that make sense?
Yes, thank you very much. How about if that patent related to the medical device, if they have proved that it go for clinical trial? Is that increase the value of the patent?
I would certainly think so, depending on the context. It depends on the nature of the device, but it does help because one issue with medical devices, as you well know, is that if it's not approved, there's a risk that you can't sell it, and then therefore the patent can't really be used. So the closer you are to making the product that you have patented, the more valuable that patent becomes.
Okay. Thank you very much, Kirk.
Sure, no problem.
Thank you, Professor Yingyot. All right, in the audience, I also see Professor Nathawood. อาจารย์เป้งค่ะอาจารย์เป้งอยากที่จะมีคำถามหรือมีคำปิดกล่าวสั้นๆไหมคะ
Hi, Kirk.
Hi there.
Thanks for your talk. I think it's very inspiring. Not for only for AI, but in Thailand, for software development, it's quite a myth about very difficult to patent.
Oh yeah.
I'm not sure that it happened anywhere in the world or it's just in Thailand. And do you have any suggestion for that?
So you're right, Thailand's very difficult. Which, honestly, it's very possible that other countries, including the United States, will eventually follow Thailand's route. There are rumors that other countries might become more strict over time. My recommendation is, as much as you can possibly do so, I keep mentioning these different claims with examples of different computers. Keeping in mind that I'm not a Thai patent attorney, but the way we in the US have always handled that problem has been to make sure that we explain our inventions in terms of multiple computing devices and in terms of a system, not necessarily a software executing on a computer. So, for example, I do a lot of computer networking work, right? So firewalls and things like that. There's a way to describe a firewall as just one computer filtering packets. That can be extremely limiting. But if I were to explain that firewall operating in a network involving computing devices, sending packets, receiving packets, and so forth, that tends to make the argument stronger. It makes it feel less like software. So to the extent possible, when we're talking about medical devices, I would focus more on the way in which the device is used, any sort of context in which it is operating, not necessarily as being as a computer. So what I would always avoid is thinking of your invention as code executing on a computer. I would zoom out and think of your invention in the context of where it's being used, how it's being used, and the ultimate effects it has in terms of diagnostics or whatever. The same applies with pharmaceuticals, the same applies with everything else. So in other words, my answer to you is think zooming out, think about what other computing devices are involved, think about what other players are involved, and see where you can try to explain yourself in the bigger picture.
So it's just like what you mentioned, that don't try to patent the black box, right?
Exactly.
But think about input, output, and environment.
So you're absolutely correct. In fact, this slide here, it used to be, instead of AI/ML model, I've done a similar presentation where it said computer. So
I see.
Yeah.
Okay, that makes sense to me now. Thank you.
Yep. Thank you.
Thank you very much, Professor Nathawood. All right, we have one last question in the chat from Kun Jitwisut. If we are in the situation that our inventions are somehow resemble or similar to something that is already patented, what is the practical strategy or tricks to make it possible for our invention to be patented?
So this is not uncommon. I know it can feel defeating because it's very common that you will find inventions before you that are similar to what you've done before. Don't worry that much. This is very common. It's one way to think about it is it's like research. There are people who have researched before you. They have probably researched similar-ish things. So the question is not whether or not someone has thought of the same problem as you. Oftentimes the question is whether or not they've done exactly the same approach as you. Let me give you an example. Let's say we're talking about a diagnostic system involving, we're trying to detect brain tumors using CT scans with AI/ML, right? I'm throwing this out there. So again, we've said don't do the black box. So perhaps there is someone out there in the world who, before you, tried to make a machine learning model identify brain tumors in CT scans. In fact, it's very likely that's out there, I'm guessing. But maybe they're not doing it the exact same way you're doing it. So for example, the steps beforehand, the way in which you're receiving data may be different. The training data for the machine learning models might be slightly different. The output might be different. So one way we handled this situation is when I'm drafting a patent application, I say in the patent application, I say, look, people have tried this problem before, but we did it a little bit differently, and that made it better. And that's all you have to prove. You don't have to prove that it's remarkably different, that it's never been done before. All you really want to prove is, this is a problem people recognize. Someone's tried this before and it worked okay, but my way of doing it is this much better. And that's all you have to prove. So keep in mind that if you see someone who's done something similar to it, that's fine. That's normal. Now, if you know that, one thing I'll flag for you is when you file a patent application, you have what's called a duty of disclosure. This applies in virtually every country in the world. You have to give the patent office what you know about other inventions. So for example, if you know someone who's done something similar before, you give them an example by giving them the documents. So if it's no research paper, for example, you will send to the patent office the research paper. This is a really good thing though, because if you start that patent application by saying, I've seen this research paper, I know what it says, and I am different, that is excellent. It will make your patent stronger. So don't feel scared about telling the patent office what people have done before. You actually should do so because doing so makes your patent stronger. Otherwise, when you sue someone with that patent, it is possible they will try to destroy the patent with a research paper. They'll say it should not have been allowed. If you start your application by saying, I know what's out there, I know who's done it before, and I'm better for this reason, this minor reason, you actually end up having a stronger patent. So don't be discouraged. It's extremely normal, and just consider your minor differences and how those make your system better, and that's all you have to do.
Thank you so much, Kirk. We received one question from our Facebook Live. It's very similar to the question just asked. But let me just ask it again in case there are some other takeaways. What should be my strategy if I've found that there is already a similar patent pending or filed, but I am confident that my invention would be better? You mentioned a little bit about talking about how your invention is better than the existing one. Can you talk a little bit more about that and how we can make that distinction?
Sure. So I'm speaking in the abstract, but here's how I would handle that. So let's say we're filing our patent and we're preparing our application, and I know that someone else has done something similar. I would address it in what, in the US at least, we call the background section. I would say, look, this is out there, we've reviewed it, but it has a flaw. There's probably a flaw within that other invention somewhere. Or since you say it's better, there's probably something there that you're doing better. So what I like to do is be very upfront. I say, look, someone's done this before and it's okay, but there are some problems with it. And those problems are X, Y, and Z. What I have done is similar but different. And the way I do things differently fixes problems X, Y, and Z. So for example, there are many, many patents out there relating to, different ways you can make a tire. And there are tires out there in the world, right? Cars have tires and have had tires for years. But the small incremental improvements are where patents are provided. So those patents oftentimes say, look, we've had tires for 100 years, but my tire is better than the other tires for a very specific reason. So other people make tires with rubber, they make tires with beads and all these other things. But mine's a slightly bit better than everyone else's. And here's why. That is awesome. I cannot explain to you enough how good that is. So you shouldn't view this as a problem. You should view it as an opportunity, because when you tell the patent office that style of story, it explains to them better. They're not feeling that you're trying to get a patent you're not entitled to. Instead, they understand, oh, this person is improving the state of the art. They're actually making genuine improvements. So I cannot emphasize this enough. If you see this stuff out there, don't feel discouraged, don't feel sad. This is not, you're not trying to be that different. In fact, these sort of situations are perfect because it gives your patent the opportunity to explain why it's so important to exist. So you should feel strong about it. You should feel good. That's really all there is to it.